Hi folks, you're with Tacitus Today, your pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk about the indictment of President Trump in the District of Columbia, that's Washington DC, courts, and this is the Jack Smith indictment, alleging some sort of untoward goings on in and around the election, following the election up to January 6th, which has become a holy grail for the globalist controlled Democrats as a way of sort of reverse de facto legitimizing the very, very questionable presidential election. So I want to particularly sort of go through how an activist judge, and many are claiming with good reason from the looks of it, that they believe that the judge appointed to hear the Trump case is an activist on the far end of the activist scale, that will you couldn't get someone who'd be more hostile to Trump than this judge. Sometimes people I've seen online, and people have been actually asking me, how is it that a judge can affect the outcome of a trial? The evidence and the facts and the jury and all these sorts of, that determines the outcome. The judge is kind of just there as just to make sure that the rules aren't being broken and so on. So, how is it even possible to do it? Well, that demonstrates a lack of understanding. Now, very few people, if you look, it's a very small percentage of the population knows, has seen the inside of a courtroom, and certainly not a trial of this scale. Some people maybe have been to a court of petty sessions over their next door neighbour owes them $50 or something like that, but not a case like this. So now I'm not a lawyer, by the way, but I've spent a lot of time doing legal documents, filing them, going into court, and spending time in court and putting forward arguments and so on. So I have some quite intimate understanding of the details of how it works. And I've also had the misfortune of being in front of an ideological, fanatical judge that's determined to produce a certain outcome along ideological lines rather than based on the evidence. And this is really what Trump is up against. Given it's an activist judge in an activist court with one presumes an activist jury, then no one really cares about the facts. But even if they did, the judge can make sure that those facts don't occur. But how can the judge do that? So what I'd like to talk about now is just how activist and ideological fanatical judges behave in court. Now, their behavior is illegal, and you can appeal it, by the way. But very few people, Donald Trump does, but very few people have the resources to make the appeals. Someone of Donald Trump's wealth can put together a legal team, for example, and they can litigate for years into the future if it comes to it. But most people can't. Very few people, in fact, can. You're looking at one in every 500 or 600 people has those sort of resources. So really, when a court goes ideological, there's very few, unless they're going to get external support. Like the famous case of the Christian baker. Without the Christian organisations funding his legal cases, he couldn't do that. I mean, he's just some small guy with a small business out in the suburbs. He can't afford gazillion-dollar litigation. Nor could the other side, by the way, but the resources of the state were being thrown into chasing that baker, and he got help in fighting back, and I'm glad he did. But often the issue is the resources available to fight these cases, not the merits or non-merits of the case itself. So coming now to deal with the activist judge, how do judges affect things? And this is really going to be the nub of the case with Trump. How the activism works. Now, let's say the allegation is, and I'll take it away from the Trump here, Billy Bob, you did this. You were in this city and this place, and you did this, and you said that. That's the allegation. Remember, that's an allegation. So the prosecution or whoever the other side is has got to prove this in court. Well, that's ostensibly how it's supposed to work, but does it work that way in reality with an activist judge? And keep in mind, we're talking an activist judge here. So Billy Bob says, well, or Billy Bob's legal team, it doesn't matter, says, well, I actually wasn't in the city at the time. By the way, I've got 5 witnesses and they've all filed affidavits to say I was somewhere else. And so the judge says, well, I'm not prepared to accept those affidavits unless all those people are in the court to be cross-examined. Now, the judge doesn't have to do that. There's no law that says the judge has to do that. The judge is arbitrarily doing that. Now, by that arbitrary action alone, now to a jury or someone else, may go, oh, well, that's okay, I guess. Well, why can't those people come in? But those people are spread out all over the place. They've got to leave work for a day. They've got to travel in. The judge won't give fixed times when they say, okay, well, I'll hear those people's evidence at 10 o'clock or midday or whatever it might be. The judge doesn't do that. You have to line up and sit outside outside the court in the waiting area, and you got to sit there cooling your heels while you wait for the possibility that you'll be called to give evidence that day. So anyway, the judge just said, well, that sworn testimony that is 99% of the time considered as evidence. The judge is saying, well, I don't accept that. I'm not accepting it until those people are here in the court so they can be cross-examined. Now, that's an arbitrary act by the judge and one that's rarely applied. Now, here's also the activism. Will the judge apply that same standard to the prosecution? For example, well, you say that Billy Bob was there at the time. What evidence do you have to prove it? Well, we've got these depositions. Oh, I'm not interested in those depositions. You bring those witnesses here to be cross-examined. But the judge doesn't do that. The judge only puts that burden of proof, the higher burden of proof, on one side, not the other. Now, that's in terms of due legal process, that's a real breach. I mean, that's serious. That is heading into the serious territory there, where you apply a higher standard or burden of proof on one side and a much lower standard on the other. But this is an ideological court, and they say they have the right to. We said Billy Bob's a bad guy. We have the right to do that. The prosecution is going after Billy Bob, which makes them the good guys, so they should have a lower burden of proof. All they have to do is whisper inaudible murmurs to say that Billy Bob did something, and that is a fact, and we will accept that. If Billy Bob says no, then he better have 1 million witnesses with 1,000 depositions each. Yeah. So the burden of proof is much different, and this is an activist ploy here, and we'll see certainly this or an approximation of it for Trump. Now, the other thing is the coordination between an activist judge and, say, the prosecution event they're trying to prosecute somebody. So there'll be talks before and say, well, look, you better make sure you've got your witnesses in the waiting room, because I'm going to say to the other side that they, or have them waiting in the cafe around the corner, have those witnesses, because I'm going to tell the other side, Billy Bob's side, that he's got to have witnesses in the court to be cross-examined. I won't accept the depositions as evidence. So you better make sure those witnesses are sitting around the corner in the coffee shop, cafe. So when I say that I want the witnesses there, you can wheel your witnesses out straight away, but Billy Bob's going to have to madly scramble to get his witnesses together. So they'll pre-arrange tactics. This is also a big part of how these activist judges and the activist prosecutions work. And I have no doubt, I believe, in my opinion, I have no doubt this tactic will be used against Trump in the indictments or the hearings, rather, in the case as it unfolds in DC. So these are just two tactics. Now let's suppose Billy Bob goes, okay, I can get those witnesses into the court, Your Honour. I can get them in here tomorrow. Or you can see from the look on the judge's face, the judge isn't happy with that. All right then, Billy Bob. But remember, the judges dismissed it, that those sworn depositions that have been, hard work and been put together with lots of running around, getting the witnesses to write it all down and that sort of thing. That those depositions, the judges said, well, I'm not accepting those. If you can't bring the witnesses in to be cross-examined, I'm declaring those statements that you weren't in the city at the time. I'm going to declare that evidence as inadmissible. Now, just think about this for a minute. They're saying you were here, you were in the city, and you did this. Now you can say, well, that can't be right because I wasn't even in the city at the time. You have to prove that with evidence. Now, if your evidence has all been thrown out for no reason, the judge has just arbitrarily decided, I'm just not accepting that because you don't have evidence. So the judge has adjusted the bar of evidence you have to meet and done that arbitrarily and on the fly. If at the beginning of the case, the judge had said, well, anyone who's got depositions, I want the witnesses in the court at the same time, that would be different. But the judge hasn't done that. The judge waits until the evidence is about to be entered and says, no, I'm not accepting it. Now, that's your only evidence that you weren't there at the time. The judge knows that. That's the only evidence. So if the judge dismisses the only evidence you have, then that means the allegations against you must be true because your refutation has just been trashed by the judge, just arbitrarily trashed by the judge. Not there's facts, errors or anything there, just the burden of proof, the bar of the evidence of the evidence bar you must meet has just been jumped up a few notches, but just suddenly. So you've then got to scramble to meet now this higher burden of proof. This is very much an activist ploy. The reverse is for the other side, where the judge will just bump down the burden of proof a couple of times. Just hang on a second. I've got a message here, and I'm waiting on a message. Okay, good. No, don't worry about that. So this is a classic tactic, but to a jury or to someone that doesn't know anything about legal practice or legal processes in a court, they look at this, what's going on? Oh, I suppose that's all right. Well, if the judge said it, it must be okay. The judge wouldn't. The judge must be abiding by the rules. I mean, if the judge isn't abiding by the rules, then the whole thing's a farce, which indeed it is when you come in front of an activist judge. But this is to someone else. Most people just wouldn't know. They sit there a little bewildered watching and, I suppose it must be all right. But it's not. It's not. When you put a higher burden of proof on one side and a lower burden of proof on the other side of the two sides arguing in court, then you are horribly corrupting the due legal process of the court proceedings. And again, this is clear. And I have personally firsthand watched this happening in real time, so I can comment with some authority on this. Now, other tactics they use. Let's suppose Billy Bob gets all the witnesses. So he gets all these witnesses, the ones who've done the depositions the judge is disallowing, and gets all these witnesses in for cross-examination. So Billy Bob or his legal team says, well, okay, we got the witnesses here, Your Honour, and we'd like to bring them in for examination or cross-examination. So the judge, I'll rule on that presently, or I'll rule on that soon. So the hours roll by, and these witnesses, of course, they're taking a day off work and this and that, and so they're now saying, well, look, we can't come back tomorrow. Then Billy Bob is which Trump could do, by the way. But Billy Bob's now in a position where he's got to pay them. So, well, look, I'll give you, I'll pay your traveling money, or I'll pay you for a day. But that puts him in dangerous territory now. He's compensating them for their time off work, or the lost pay, or maybe a traveling cost or something like that, or accommodation if they have to. It's a long distance travel and they need to stay the night. That could then be used by the other side to say, well, you corrupted, you paid them, you bribed them to say what you wanted them. So it's difficult territory there. So you really got to be careful on that. So the judge won't rule on this. No, I'll think about it. Well, judge, you've said you want these witnesses here. They're here. Can we bring them in for the witness box? I'll rule on that presently, the judge says. Then you say, well, can the witnesses come back tomorrow? The judge might ask, or judge does ask. Can these witnesses come back tomorrow? And you go, well, no, one of them can, but the others can't. So the judge, then you can see okay, all right. Well, all I got to do is drag it out until the end of the day, or I can close the court early on some bullshit excuse, and then say I'm not going to hear any more evidence, and then these witnesses are unavailable. So then the judge can then go, well, you couldn't get the witnesses here to be cross-examined, Billy Bob, so I'm disallowing all your depositions. But I had the witnesses here, Judge. Oh well, we just didn't have time. Too bad for you. So judges use that. So they'll deliberately drag the case out or drag the day out until those witnesses can't stay anymore. And then, have all your witnesses gone home, Billy Bob? There's no witnesses out there? Sure, there's none there? Okay, I'll hear them now then. And they're that brazen. These activist judges are that brazen in how they'll try and manipulate the witnesses or manipulate the hearing of witnesses. So notice the steps here. I'm not accepting these depositions, Judge said, until you have the witnesses here to be cross-examined. So you get the witnesses to be cross-examined. The judge then refuses to hear from those witnesses, won't allow it, deliberately uses delaying tactics. So the witnesses are no longer available and they've gone home or back to work or wherever it is, and they're no longer available. And then the judge rules, well, you haven't, the depositions, I told you, you haven't got the witnesses. It's all, I'm not going to accept any of it. That means you were there, Billy Bob, which means you fucking did it. And so those tactics, those brazen tactics. Now these are tactics, of course, that can be appealed. So again, if you've got the resources as Trump does, you can appeal it. But the judge may order, when the judge gets the guilty verdict, which is obviously what they want, they may order you be arrested immediately and thrown in the slammer. The judge has that authority. The stroke of a pen from a judge on a bit of paper, you're in prison. It's that insane. But because it was assumed that judges could never be corrupted. How wrong could they be? Now again, the appeal can be launched and that's something, but the optics of having someone in prison for a day or two is what the activists want. Would you vote for this man? A shot of him in handcuffs being led into the prison. So, that type of stuff. Those are the optics that the activists want. So anyway, now Trump will win on appeal. There's no question of this. Even if it has to be appealed up to, taken up to the Supreme Court, Trump's going to win. We know that. But in the meanwhile, they're doing as much damage as they can to him, getting as much optics for them to use during the presidential election. And it's those optics and those charge sheets and things like that they want to wave around. And they're going at it with gusto and aggression. So now on top of that, the judge can just arbitrarily say, the prosecution has said that you you were inciting the crowd to launch an insurrection to overthrow the government and to something sort of very emotive and dramatic and so you have to prove that you didn't do it. Now the way the burden of proof works, or certainly in the system of law that we have in places like the United States, Australia, is the presumption of innocence. But an activist judge reverses that. The allegation against you is the fact. That is the concrete, accepted fact, and you have to prove that it didn't happen. And then every obstacle, such as not refusing to accept the depositions, not allowing witnesses to give testimony, and so on. Now, it also goes that any evidence that is like a kill shot type evidence in favor of, in this case, Trump, the judge can arbitrarily disallow it. So, say if the key person in the government says, "Look, the whole thing was a setup. We did everything we could to try and create the illusion of, and we coordinated with the media to tell all these lies, and we did this and we suppressed that and we did so and so." Then the judge can arbitrarily say, "I'm not accepting that evidence," and that's it. Okay, so that this means the power of the allegation is huge, because the evidence in refutation, or any evidence that calls into doubt or into question that evidence, is just ignored. And so they go along ideological lines. Now they can, they can say, well, he's a straight white male and he once grabbed a woman's ass 25 years ago. Oh, fuck, that's it. Take him out back and shoot him. So they can present the ideological case of, look, we're talking about a bad guy. Even if he didn't do this, even if he didn't do any of these things, does it really matter? Because we're talking about a bad guy. So why do we just find him guilty? I mean, fuck the evidence, screw the facts. There's an ideological thing here. Now, you saw that sort of attitude in things like divorce courts, which are 100% ideological, in divorce courts where the guy hadn't the man, the father, or the husband, hadn't done anything wrong or hadn't done anything bad, but so he hasn't done anything wrong. He hasn't done anything bad. So he's a good father. So he's a good. Who cares? He's a straight white fucking male. He's part of the oppressor class. And as we know, Hitler was a straight white male. So therefore, he must be Hitler. So he's fucking bad. And so it's drawing these insane broad brush parallels of the culpability of one person based on a very remote and hugely indirect association with another, and the other is the symbolic character of all that is evil in caricature form even, and then drawing that parallel and saying, well, look, he's a bit like that person. Hitler drank water. Trump drinks water when he's thirsty. So therefore, and drawing those ridiculous and absurd and insane parallels. But in the ideological world these people live in, that's not an insane parallel. It's it's the same. Yeah, all white men are oppressors. So therefore, and so these are just among the, I could go on here, but these are among the tactics that are used by ideological judges. Now, most people can't afford the just don't have the resources. They can't appeal it, and the judges know this, and so they'll even check on the financial. Has this person enough money to appeal this? And once they're confident that person hasn't got enough money, they even go in harder, knowing that the person can't fight back. And this is what, again, ideological judges do. Now, here's another one. This is, again, I had sort of firsthand experience with. There's an allegation someone had misused corporate funds was an allegation in one case, and I was involved in that one, and I was looking at the interplay between the parties, and there was a forensic accountant. I'll use that term. Forensic accountant had gone through the numbers and said, "Well, no, Billy Bob hasn't. There's no appropriation of funds at all. The amount was $100, and it was exactly $100. This was part of the deal, and da da da." So now I could tell they wanted to get Billy Bob in this case. That was obvious. And again, the judge was activist and wanted to stick it up Billy Bob and gouge him for more money. So the very, very partisan, very activist financial analyst that the other side used was, their work was so sloppy and pathetic that I'm surprised it even was allowed into the court. But the judge grabbed onto it because it made Billy Bob look bad. Now, the forensic accountant that Billy Bob had to pay for, and whereas expensive, the forensic accountants charge pretty serious money to be witnesses. So they're in court, and the judge kept on delaying and delaying and delaying, and into the second day of hearing from Billy Bob's witness, which would have completely exonerated him. And so the judge was deliberately making it hard for Billy Bob to get his witness up. Again, the activist judge. The judge shouldn't do that. An impartial judge wouldn't do that. But we're not talking impartial. We're talking activist here. So they kept on delaying the thing. Meanwhile, Billy Bob's, spending serious money for this witness. The witness then finally, this forensic account was then finally brought in. Now, bear in mind, Billy Bob spent something like 3 to $4,000 just while this person waits. This is separate from the report. So they the judge kept on delaying it, and so anyway, the witness comes up. So Billy Bob's team asks some pretty kill shot type questions, and that the so in summary, the lawyer asks the expert forensic accountant, in summary, would you say, in your opinion, Billy Bob has not misused any funds at all? Is that the conclusion, which was already the conclusion in the report? So the judge at that point almost leapt out of the fucking chair and said, "Don't answer that question. The court is closing early today because I've got an important meeting to do." And then the judge came out with an order saying, "I don't know how long it'll be for that witness to wait until I'm prepared to hear their testimony again," because the judge has interrupted it and wouldn't even allow that answer to go through. So Billy Bob has to put up a bond of $20,000, or that witness is not responsible to come. They don't have to come again to the court or wait unless Billy Bob puts up a bond in advance of $20,000. Now, again, the judge is deliberately making it difficult for Billy Bob's witness, the independent forensic accountant, and by not allowing the witness to answer, as the lawyer says, so Billy Bob did or didn't do this. The answer is going to be no, Billy Bob didn't do it, and there's a deposition in writing and evidence from the expert witness. So the judge would have had to let Billy Bob off, or let him off the hook for the fine and all that sort of stuff. But instead, the judge deliberately intercedes to prevent that evidence from acquiring. Now, Billy Bob can't afford the bond. As it turns out, he's already bleeding money anyway. He can't afford the bond. So the judge, that's it. If you can't afford the bond, you can't have your expert witness back. Because the expert witness can't come back, I'm not going to allow your deposition, and I'm not going to accept anything it said. Therefore, and so the judge could throw the whole. So the key witness upon which the entire case really revolved, this independent forensic accountant, the judge will simply not allow that evidence to be entered. So these are the sort of tricks and that an activist judge uses. Now, another one I came across was where one of the parties was recorded on like an answering machine or an answering service, threatening a witness, saying, if you go in, you dare go in for a witness as a witness to give evidence against me, I'm going to make sure a bunch of goons come around and beat you up. And this was recorded, and so the other side brought this into the courtroom and say, look, this is what we're dealing with. But again, the activist judge was don't accept it. So the judge has these arbitrary powers. So the point I'm making here is that an activist judge can do these sorts of tricks and more that may on the surface appear consistent with law or consistent with procedure or administration of law and so on. But in fact, they're not. They're brazen and blatant efforts to alter the outcome for ideological reasons. You've been with Tacitus today, your Pushback channel. Thank you for listening.